Let's pick it up here. Former commissioners from the Truth and Reconciliation Commission are calling for more investigations to happen. In fact, they're calling for an open inquiry into so-called suppressed cases. These were matters that were referred by the TRC for prosecution. Now, the TRC, you may recall, did most of its work in the 1990s and concluded the process almost 20 years ago. It heard evidence from hundreds of former apartheid police officers and people affected by the brutality of the apartheid regime. To talk more about this, we're joined by the Executive Director at the Foundation for Human Rights, Yasmin Sooka. Yasmin, a very good evening to you. Welcome to News at Prime. Grateful for your time. So, as things stand, government, at least via the Justice Minister, Ronald Lamola, has announced an inquiry. What you are saying is that you want a different kind of inquiry. Why has what has been announced by government, why is it not sufficient?
Thank you for your question. I think we have to look at a number of questions. The first is that we have a hiatus of 23 years in which these cases, investigations were deliberately suppressed. And then secondly, we also have the allegations that in fact the executive made a deal with the apartheid perpetrators not to investigate and prosecute. So the minister's announcement, I think, and the part that we welcome is the fact that they're employing a lot more prosecutors and investigators to deal with these cases. That's a welcome move. But his announcement around an inquiry is one which is quite problematic, because what he said is that he will be appointing a judge to manage this inquiry. Now, that presupposes that that is not under the Commissions of Inquiry Act. And he never spelled out at all what the judge's powers will be in relation to the inquiry. And when he was asked questions about whether or not it will be open, he said he would have to talk to the judge himself. Now, in our country, we have a constitutional court judgment, and that is in the case of Heath versus the Road Accident Fund, where the Court unanimously said that judges cannot be used in internal inquiries affecting the executive. That is illegitimate and unlawful and would compromise judges. And so it's really important that when the minister sets up this kind of inquiry, it's done under a proper process. It abides by the principles that underpin the work of the Commission, which was openness, transparency, and independence, because the questions that the inquiry will have to deal with are ones that have come before both the full bench appeal in the Timor case and the Supreme Court of Appeals judgment, where there was confirmation that in fact the executive interfered and in fact deliberately suppressed investigations. The second question, of course, is why has it taken so long? It's 23 years ago since the Commission handed over a list of more than 300 cases to the National Prosecutorial Authority. What happened in the 23 years? I think the victims are entitled to know. And then, of course, many of the perpetrators, including the late João Rodrigues, have gone to the courts to say, actually, why are you prosecuting me when I should benefit from the deal that was agreed to between the executive and apartheid perpetrators? And so I think as victims of apartheid crimes, they deserve better. They need to know answers, and that can only be done by way of a proper commission of inquiry.
And just on that, the minister made these comments about this internal inquiry, I think it was on the 5th of November, 7 days ago. Has he been able to give you any kind of clarity on how it's going to work?
Deathly silence, despite the release of the statement and despite the statement having gone to him. And you know, it's quite important when you realize that it's the minister who said he will appoint the judge, because the only person who can actually establish a commission of inquiry under the Commission of Inquiries Act is actually the president. And of course, when the minister, he made his statement at the inaugural lecture of the Kalata Foundation, and that is when he was also asked by Lucanio Kalata, so will this be an open inquiry? And he was very quick to say that he doesn't want to get into the details. He doesn't want to be making policy around this, and he will have to talk to the judge. Now, of course, when you set up a commission of inquiry properly by way of the president and by way of the right, legislation, then automatically the normal rules that apply to commissions of inquiry will come into play. And of course, the Truth Commission set down the principle that all of these hearings need to be in public because, when the original TRC legislation first emerged, the language in the draft bill was in camera, behind closed doors. And so as survivors groups and human rights groups in the late 1990s, we mobilized, we demanded parliamentary hearings, and as a result of that, in fact, the language in the law changed. And so that then became the bedrock principle on which all commissions of inquiries began to operate in our country. Open, public, transparent, with powers given to the commission to be able to subpoena people, to secure evidence, and in fact to allow the testimony of witnesses to be heard. And so I think that's the appropriate model when you think about the seriousness of what happened in this case.
So you believe, of course, that a deal was struck by people in political office to basically sit on these cases because they were referred for investigation about, 20 years ago now. Do you believe that the people responsible are likely still in public office today or in the prosecutorial authority?
I think that that's the question that this commission of inquiry must answer. We have the affidavits of two, former heads of one of the NPA, Vusi Pikoli, and the other of the PCLU, Anton Ackerman. And in both cases, they talk about a task team that was established to begin to look at this kind of deal. And then, of course, in the Timor case, when it first came to the full bench appeal, you have the affidavits of Tari Pretorius and Chris McAdam, in which they allege executive interference. But in addition to that, you have the perpetrators themselves alleging that there was a deal. And a few weeks ago, the de Klerk Foundation also said, why are you prosecuting these people when there was a deal that there would be no further prosecutions? So these are the most important issues which such a commission of inquiry would need to look at. And when you think about the fact that the rights of victims have been prejudiced, you had the death of Mr. de Klerk, you've had the death of Jean Rodrigues, you had the death of Stephen Whitehead in the Agate case, you've had the death of Timothy Khadebe in the Nakatula Simelane matter. We are in a race against time. And the longer we delay on these issues, the more we prejudice the rights of victims. And that in itself constitutes an obstruction of justice.
You mentioned F.W. de Klerk. You were a commissioner with the Truth and Reconciliation Commission. For the benefit of those who, for whatever reason, had not been following the work of the commission or were too young to have tracked what had been happening, how would you describe de Klerk's approach to the work of the commission?
Well, I think you will know that the commission was not very happy when Mr. de Klerk appeared before the commission, because Mr. de Klerk, right up until his recent apology, which emerged yesterday, has never admitted that apartheid was declared a crime against humanity by the United Nations. He also refused to acknowledge that the apartheid state had become a criminal state which had established death squads where, in fact, the State Security Council authorized the assassination of activists. And of course, in the case of the Cradock 4, in the case of the Umtata raid, you have that authorization, which Mr. de Klerk never really explained. And when he came before the commission, he was very careful to say that it was not the policy of his government. They didn't authorize any of these activities. And in fact, if the security branch and security forces carried out these crimes against humanity, then they did so as bad apples. Now, this is, of course, a very important component of our history. Apartheid was a systematic and widespread policy. It was an attack targeted against the opponents of the state and the black population at large. In terms of civil and political violations, these included torture, killings, enforced disappearances, abductions, and in the case of the socioeconomic rights dimension, it includes the deprivation and the lack of access to the economy, to education, and the land question. Now, this was not, these policies were systematic. The State Securities Council in our country, at which Mr. de Klerk sat at 90% of the meetings.
All right, I think we've lost Yasmin Sooka, former Truth and Reconciliation Commission Commissioner, speaking to us about suppressed cases. These were matters handed over by the TRC to the prosecuting authority to investigate and bring people to account. Now, currently, the Justice Minister said an internal inquiry will be held. The former TRC commissioners and families of some of the victims saying they want an open process that they can follow, that you and I can follow, to make sure that there's enough transparency in dealing with that, especially with questions going about whether people who were either in government at the advent of democracy, who are still possibly in the public service, may have struck some sort of deal to sit on these cases. We will continue to track that story right here on Newzroom Afrika. And